Great. Thank you all for joining us tonight. We're going to go ahead and kick off. Welcome everyone to our NEPA 101 and writing comments for the CDT webinar. A couple of notes of digital housekeeping before we kick off. Please feel free to engage in the chat. Let us know where you're calling in from. And also a note that this webinar will be recorded and will be shared publicly afterwards. So just keep that in mind as the webinar progresses. And then I will make a note on Q&A in a couple of slides. And then finally, I just want to note that this is our second annual training. Last year, we focused on how to advocate for the CDT and other trails through legislative processes and working with elected officials. So if after this webinar you're feeling really jazzed up, want to look for another one, I will share that link with the recording after the webinar. So kicking off with some brief introductions, my name is Claire Cutler. I am our trail policy specialist at the Continental Divide Trail Coalition, and I am based in Denver, Colorado. And I'm going to pass it over to Sharon to introduce herself.
Hello, I'm Sharon Buccino, and I serve on the board of the directors for the Continental Divide Trail Coalition, and I am in Laramie, Wyoming.
Awesome. Thanks, Sharon. And if all of our attendees are comfortable, if you would like to do so, please feel free to introduce yourself in the chat. And if you want to share kind of what drove you to attend tonight, or if there are any land management or NEPA analysis decisions that have been top of mind recently, just kind of let us know what motivated you to join us this evening. I'm going to run through a quick agenda for the evening. We will start off with the basics of the National Environmental Policy Act, including its history and its purpose. And then we'll dive into how to write comments, both for the CDT and then also tips for writing NEPA comments more broadly. And then finally, we will do Q&A at the end. If you want to send your questions at any point throughout the presentation, please feel free to. We'll answer them all at the end. And to do that, we're going to use the Q&A feature. So that should show up either on the toolbar at the bottom of your screen, or if you don't see it there, if you see a button that says More, you should have an option for Q&A. And you can send your questions there at any point. You can also send them in the chat. We just may not keep as good track of those. So just kicking off, in case anyone isn't already familiar with the Continental Divide Trail or our work at the CDT Coalition, the CDT is a 3,100-mile national scenic trail that runs from the U.S.-Mexico border in New Mexico to the U.S.-Canada border in Montana. And it's part of the National Trails System, which was established under the National Trails System Act in 1967. The National Trail System Act created a system of continuous long-distance trails across the country meant to highlight significant scenic or historic routes. The CDT was about a decade later designated as a National Scenic Trail under the National Trail System Act in 1978. Today, there are 11 National Scenic Trails and 21 National Historic Trails, as well as over 1,300 National Recreation Trails. Similar to a national park or national forest, each national scenic or historic trail is administered by a federal agency. So the administering agencies oversee the management of the trail, including coordinating across land managers and private agencies, planning for the trail, planning maintenance for the trail, and more. And the CDT is administered by the U.S. Forest Service. Here at the CDTC, our mission is to complete, protect, and elevate the Continental Divide Trail, working in partnership with the U.S. Forest Service. And this can take a lot of forms. We do outreach and engagement work with gateway communities. We do physical work on the trail and volunteer projects. We do trail information and mapping. And then the part of our work we'll be talking about tonight is our trail policy and advocacy work. And as we'll talk more about later, a big part of our policy and advocacy work is participating in NEPA processes that have the potential to impact the CDT. I'm going to pass it over to Sharon now to talk a little bit more about the history and purpose of the National Environmental Policy Act.
Great. Thanks, Claire. So, should give you a little bit more about my background. I am a lawyer and I've practiced for over 30 years now. I started up in Alaska where I clerked for the Supreme Court there and then went to Washington, D.C. and spent most of my career working as an attorney for one of the national environmental organizations, the Natural Resources Defense Council. So as a lawyer, I've worked with a lot of laws. But I have to say that NEPA, the National Environmental Policy Act, is my favorite. And there are a couple of reasons for that. One is that is the potential power that it gives citizens and those affected by federal government decisions, but also because of the language in the statute. It's actually a very short statute, but it's very eloquent. And it was the product of the birth, really, of the environmental movement in the 1960s. It was passed by Congress in 1969, but then signed by President Nixon in 1970. And when I first read the text of the statute in law school, its words really they offered me hope because NEPA speaks of the nation's commitment, and I'm going to quote, and you'll see this quote from the statute there on the screen, the nation's commitment to create and maintain conditions under which man and nature can exist in productive harmony and fulfill the social, economic, and other requirements of present and future generations of Americans. And this was really what I went to law school looking for, a vision of a world built on respect, respect for animals, for land, and for each other. And NEPA provides a vision for that, but also a path to get there. So next slide. So why does NEPA matter? And if we start by looking at the statute's intent, has two critical purposes, which are really at the core of our democracy. One is to ensure that government decisions are informed. And the second is to provide public participation and to ensure that the decisions that are made give the people affected by those decisions a say in them. The other thing I'd like to flag is that NEPA talks about the human environment. And as we saw in the last quote, it's a very broad definition of environment, and it does include social and economic aspects, as well as health. And it recognizes and requires our government to analyze the impacts of its proposed decisions on each of us, on our health and our economic well-being, as well as on our natural surroundings. Next slide. What agencies are involved and what are their roles and responsibilities? So since it's a federal statute, we need to recognize that it applies to federal agencies. But because the trail, the Continental Divide Trail, goes through a lot of federal land, it is affected by a lot of by decisions by a lot of different federal agencies. And we've just listed some of those there. The Forest Service and the Bureau of Land Management, both those agencies manage land that the trail goes through. U.S. Fish and Wildlife Service, Bureau of Reclamation, Army Corps of Engineers. I've been involved recently with some transportation projects, so the Federal Highways Administration, FEMA, Federal Emergency Management Administration, and also the Department of Energy. The other key thing to remember in terms of what NEPA covers and where it might be relevant is that a lot of times we're thinking about projects and permitting, approval of projects, like a mine, or a renewable energy project or a transmission line. But what it affects and what triggers its review and public participation process is any major federal action. Major has been interpreted quite broadly. But in addition to those permitting type actions, it also brings in funding, federal funding to projects that might be happening on private land. But if there is federal funding involved, like a transportation project, then the agency is responsible to look to address the impacts and include the public in its decision making. And in terms of, well, once a decision or an agency is covered, well, what happens? So there's a public participation process, but there's this requirement to address the impacts, and the agency essentially is required to look before it leaps. And this grew out of we ended up with all of the protests really and concern, and then energy behind the environmental movement, because a lot of decisions were being made where the consequences weren't being considered beforehand, and it resulted in catastrophic impacts in terms of people's lives and their communities. So, turning to that process, what is triggered when an agency's decision is covered by NEPA? How does the NEPA process work? What are the important parts to be involved in? And I'm going to talk about this in two different ways. First is a threshold question of the level of analysis involved, and then second, the stages in the process. So there are three key categories, or I would say types of NEPA analysis that are done, and some of you may have heard of these terms before. The first level is a categorical exclusion. By definition, that's intended to be the type of action that by its nature does not have significant environmental impacts. And if an agency chooses and qualifies for their action, qualifies for a categorical exclusion, then that's essentially the end of the process. There's no further environmental analysis done. If the activity does not qualify for categorical exclusion, then the agency moves forward to the question of whether a full environmental impact statement is necessary, or whether what's intended to be a shorter, less robust document, an environmental assessment is done, or an EA. And the legal requirement to do an environmental impact statement is that there may be significant impacts on the environment from the activity. So the only way an agency avoids doing an EIS, an environmental impact statement, is if either it qualifies for a categorical exclusion, or if it doesn't, they have to be able, they do an environmental assessment, and then they have to issue what's called a FONSI, a finding of no significant impact. If they cannot support a finding that there's no significant impact, then they have to move forward and engage in an environmental impact statement. So that's the level of analysis. So what are the important parts to be involved in? That goes to the stages of the process. And the statute doesn't say a whole lot about this, but over time, over the last 50 years, as NEPA has been put in place and implemented, there are these four basic stages to the NEPA process. Scoping is the first one, where the idea is that the agency brings the interested parties together and uses scoping to identify the key issues of concern. Scoping helps shape the analysis that then the agency will do. Is it noise? Is it visual impacts? Is it air quality? Is it water? That's what scoping is intended to do. From there, the agency moves on to doing a draft environmental impact statement, or if they're doing an environmental assessment, a draft. The draft, at least for EISs, there is a legal mandatory requirement that the draft be put out for public comment. It is discretionary, related to environmental assessments, the shorter, less robust analysis. Some agencies do it, some field offices of some agencies do it, but the legal mandate applies to environmental impact statements. But the draft then moves to a final environmental impact statement. And in that document, there is a legal obligation for the agency to respond to comments that are made on the draft. The final EIS then supports the agency's decision, and that is embodied in a record of decision. The last thing I'd like to mention about the process is the role of cooperating agencies, because it can be very important, especially where you have local government. For example, I'm working in the western part of Wyoming right now, with a highway expansion that the Wyoming Department of Transportation is doing with funding from federal highways. And Teton County is very concerned about what this expansion is going to look like, because it has the potential to, if they just add 4 or 5 lanes, to take out part of the pathway system for bike and non-motorized travel and recreation that the county and its community has invested in. And so Teton County has the right to participate as a cooperating agency. And there's some leverage in the process that comes with that, because in this case, where federal highways might be the lead agency, they have a legal obligation to coordinate on schedules and input with the other cooperating agencies. Often the Environmental Protection Agency might be a cooperating agency. And so working to influence, say, what EPA does and says related to a specific project that might impact the trail can be as important as working with the Bureau of Land Management. That might be the agency that's making a decision about a specific project. So I think, Claire, that may lead into what you're going to talk about next. Is that right?
Yes, that is the perfect setup. Thank you, Sharon. So, with that great background, I'm going to talk a little bit about the types of NEPA analyses that most often impact the CDT. So, like Sharon mentioned, the CDT runs through land managed by a huge range of jurisdictions. So, it runs through land managed by of the federal agencies, the U.S. Forest Service, the National Park Service, and the Bureau of Land Management. And within that, it runs through nearly 24 national forests, nearly a dozen BLM resource management offices, 3 national parks, and 2 National Park Service managed national monuments. And so each of these federal agencies utilize NEPA analyses when considering a huge range of actions that have the potential to impact the CDT. Some of the ones that we see the most frequently are oil and gas leasing processes, mining or mining exploration, timber harvesting, and vegetation management. But over the last few years, we have seen a huge range of proposed actions that could impact the CDT. So just to kind of give an idea of the huge range of activities that could impact the CDT and that we participate in, just over the last 2 years, we have seen the proposal of length of stay limits or kind of de facto permitting systems. We have seen proposals for establishing new military training areas, particularly flight training areas, over the CDT. We have seen planning processes for over snow vehicles and how they travel on the CDT in the wintertime. We have seen agency rulemaking, so even how agencies apply NEPA is often subject to public comment. And then we've also seen land management planning. So each of those many jurisdictions that I mentioned before operates under a land management plan or a forest management plan, and those are updated every 20-ish years. And so we have seen updates to plans for units that contain the CDT over the last 2 years. And so at the CDTC, we monitor all of these actions and we frequently submit comments. We submitted over 36 sets of comments last year. And oftentimes when we submit these comments, we are sharing guidance, resources, recommendations, or tools for management of the CDT. So we view public comment periods as an opportunity to collaborate with our federal agency partners in the management of the CDT to ensure that the CDT is managed consistently and that the trail's scenic views, primitive nature, and kind of experience of solitude are all maintained as Congress intended when they designated the CDT as a national scenic trail. This really helps, particularly with consistency in management of the trail, because it does run through such diverse ecosystems and through so many jurisdictions. And I just want to share 2 specific examples that I think illustrate really different ways that CDTC participating in NEPA processes impacts the experience of the trail. So last year, one of the national forests that the CDT runs through updated their forest management plan. And in the updated plan, they had a proposal for a length of stay limit in that forest for consecutive nights that you could spend in the forest, anywhere in it. And this was for leave no trace reasons, encouraging folks not to place too much strain on this pretty popular forest. But what they just hadn't considered was that the proposed length of stay limit was shorter than a hiker could safely and feasibly pass through this forest. And so CDTC, through the process, was able to collaborate with the forest, and through the scoping period, the draft period, and then particularly in the objection resolution period, we were actually able to work with the forest to establish a plan so that through hikers had an exception to the length of stay limit, given that they were following leave no trace principles. So I think that's slightly different than the resource management and physical resource management that we may think of as being subject to NEPA processes, but has a really direct impact on CDT hikers. We also see a lot of projects that would lead to forest thinning on or near the CDT, sometimes for the logging industry, sometimes to control invasive species, or for fire control. And we understand that this type of forest thinning is often necessary near the CDT, but a really common set of comments that we are submitting is requesting mitigation measures that help minimize the scenic impact on the CDT of these actions. So for example, if a large-scale clear-cut logging project is going to occur, measures like leaving irregularly cut edges around the area or leaving large trees that add character do help to preserve that scenic character of the CDT. And that may seem fairly small, I think, in the scale of a 3,100-mile trail, but the way that we consider this is that there are cumulative impacts. If we think of dozens of projects like that taking place along the trail every year, the impacts of keeping them slightly more scenic or adopting those measures do add up as you think across the scale of the trail. So with that, we're going to dive a bit into how to write comments generally and how to write comments specifically about the CDT. I'm going to start off with talking about how to find comment opportunities. So I've got 5 ways to do that here, kind of a varying range, but the first would be to sign up for our CDT advocacy alerts. I will send the link to that in the chat in just a moment, or to keep an eye on our CDT Action Center. So we update our Action Center every time comment periods are open for proposed actions with the potential to impact the CDT. And then when there's a particularly significant proposed action that could have really big impacts on the trail, we do send out an advocacy alert, and we'll oftentimes include language that you can use in a public comment. If you want to keep an even closer eye on things or track actions that may not be near the CDT, you can actually sign up for email notifications from the Federal Register. So federal agencies publish these proposed actions in the Federal Register, and you can sign up to receive emails for specific topics or agencies. So for example, you could sign up to receive notifications for everything posted from the Bureau of Land Management or everything posted about endangered species, for example. And I'll also send the link to that in just a moment. Another thing that you can keep an eye on is that when individual forests are opening a comment period, they will often publish notice in local newspapers, though I will say that the legal requirement to use newspapers of notice is being loosened at the moment, but many forests may still opt into that. So you can keep an eye on a local newspaper, and you can also look at the local forest's website. Particularly, they all have a press releases section, and that's a great place to keep an eye if there's one forest or one land management unit you're really passionate about. I would also say a lot of other organizations also do advocacy alerts, particularly state-based organizations, as well as some of the larger national organizations. So keeping an eye on other organizations is a great way to know when comment periods are opening. And then finally is a new tool that I will also send a link to in the chat. And it was recently launched. It's called the Public Lands Action Network. And it compiles all open comment periods, which is a really useful way to keep an eye on everything going on. I will note that it certainly has a partisan swing to it, and it does suggest comments. So CDTC does not necessarily endorse the comments that they suggest, but I do think that having a one-stop shop tool like that is really new and really helpful. So I think that's a great way to keep an eye on comment periods. I'm going to pass it over to Sharon to talk a little bit about her top 10 tips for writing comments.
Great. Thanks, Claire. And before I get to my list of top 10 tips, this question comes up lots. And so we just wanted to take it on directly in terms of how much weight is given to the public's comment in an EIS or an EA, and what can I do so that my comments have more weight? So Claire mentioned the action alerts that advocacy organizations do, and sometimes they even make it as easy for you to comment as possible by basically letting you just put your name in and your address, and it kind of fills out a form, a letter that is sent in. And so the question becomes, well, does that really matter? And yeah, the number does matter, but substance matters more. So what happens is they're not gonna, they may log those form letters, but what you say, if you have the time and put that time and really your heart and soul into a comment letter, that's going to have more weight. And as I mentioned, for environmental impact statements, there's a legal obligation to respond to comments received. So if an agency gets a lot of the same comment, they just have to respond to that once. But if you're writing an individual letter, then you can, like I spend time looking at environmental impact statements, and most often there's an appendix that is the response to comments. And it shows you that they get read and they're thought about, and you'll at least see, you may not agree with the response, but you'll see that in the log of an environmental impact statement. Now, I should mention that a lot of actions by agencies that are covered by NEPA do not end up in the EIS comment, in the requirement to do a full environmental impact statement. So it's important that we think about comments in the context of what you may be dealing with, an environmental assessment, less formal type of process, but in general, one that the public still has a fair amount of ability to influence the decision. A couple of other things to give your comments more weight. If you have special expertise, use it. If you're trained as a wildlife biologist, establish your credibility and then go into those comments. The other thing to think about is not just your comments, but think about encouraging others, particularly with the diverse set of interests, to weigh in with comments as well, because that's what becomes especially persuasive to an agency when they're hearing a recommendation or a comment that's coming from a lot of different types of voices. So I think, Claire, we're ready to move to the next slide and some of the top 10 tips. Okay, and these aren't necessarily in order of prioritization, but just kind of a checklist to think about as you sit down to write a comment. So evidence is really important because it's persuasive. It's giving, if you have peer-reviewed scientific studies, if you have the agency's own statements or policies, that is very, very useful to put in your comments. A couple of things as I sat down to write my top 10 tips is just really goes to the effectiveness of how you write your comment. And so instead of just having a really long two-page comment letter that isn't broken up by headings, use headings because sometimes they'll that's what they read first, and so your basic argument jumps out, and then then if they want to read more, then they read what's under that. But it allows the reader to quickly see the key points that you're making, and put those headings in bold. But think about how you're organizing your comments and how it presents itself to the reader. Along similar lines is number 3. Craft compelling topic sentences for each paragraph so that you're putting your main point that can be easily read and digested if somebody just goes down and reads the first sentences of each of your paragraphs. And then the rest of that paragraph develops the argument or the point that you're making in the topic sentence. Point 4, choose your issues carefully. I just want to take a second here to discuss this a little bit because there are two competing interests here, and you just have to think through and balance these two interests in this particular circumstance you're dealing with. But in general, it is more persuasive to pick 2 or 3 issues that you really care about and develop them fully. Choose your issues carefully. The countervailing thing to think about is, and lawyers are thinking about this if they're preparing comments, there is, if you're preparing a record to then say litigate it later if you don't get the decision you want, then you need to raise the issues in the comments to litigate them later. The basic principle is you have to give the agency a chance to address your issues before you go to the court and ask them to address an issue. So some people may think, that says, well, I should just throw everything in your comments. But when you do that, it's not as persuasive and effective in terms of really, landing a punch on the issues that you care about most. We talked a little bit about number 5 already, the value of encouraging diverse interests in your community to participate. This is particularly useful and this goes to the work that the CDTC does with gateway communities. Often there is an economic interest, or say the local chamber of commerce or the downtown development agency. They care about the trail because what it can do for the vibrancy and growth of their downtown. And so if there's somebody that you can work with from that business angle who will also then submit a comment that is along the same lines or leading to making the same suggestions, then that is a very effective advocacy tool in terms of getting the result that you're looking for. Okay, next slide, and we'll cover 6 through 10. So speak from your heart. It does matter. I mean, put yourself in the shoes of the agency personnel who's reading these comments one after the next. it really matters when they come across a story or the passion behind why somebody is making a comment, what the trail means to people, how you feel the trail's going to be impacted by the decision that the agency has before it. 7, offer an alternative. If you're raising issues about maybe what a mine that the Bureau of Land Management might be considering, there may be circumstances when a mine just doesn't work there from your point of view. But to have the most effective comments, if you raise an issue, Claire, you mentioned the mitigation. You're identifying a problem, but then you're also offering the agency a solution to address that problem. 8, invest in relationships. And this is both with other partners in your community, but also with the agency personnel themselves. And I know the staff of the CDTC is really good at this and has done it over the years, but that really matters. 9, use clear and concise sentences. I sometimes if somebody's reading something and it's wordy and it goes on, saying the same thing over and over again, they're going to lose interest in reading the comment. So be as concise and clear as you can in your writing. And then the last point, talk to other federal and state agencies, for example, EPA, Fish and Game, tribal or state historic preservation officers. This goes back to the point about cooperating agencies. Those agencies, they don't have the final decision-making role necessarily, but they can be they're sister agencies, sister federal agencies, or now the state agencies are particularly influential in what's happening on federal lands. And so those can be very powerful voices. And the other thing I'll say is there may very well, so NEPA is about process, and you may have heard that it doesn't force a specific result, but it ensures that an agency looks before it leaps. It imposes an obligation to collect information for an informed decision as opposed to dictating a certain kind of decision. There are many circumstances, however, where there's another environmental statute that is also involved in addition to NEPA. And those statutes may have substantive standards. There may be specific mandates that, in addition to the NEPA process, the agency has to meet. So I mentioned this example in Teton County out near Jackson, Wyoming. So since it involves a road and it involves a pathway, a recreational resource, that triggers the application of what's known as Section 4F under the Transportation Act. And that brings into the NEPA process a substantive standard which prohibits federal highways from funding an alternative or a project that would use the pathway unless it can establish that there is no prudent or feasible alternative. So that can add a lot more leverage to what you're trying to do in the NEPA process if there is another statute that is involved that has that substantive mandate. So the Clean Water Act does as well if wetlands are involved. So those are just a couple of examples. So Claire, that's my list.
There we go. Sorry, took a sec to find the unmute. Thank you, Sharon. That was a really great list of tips for writing meaningful comments. I'm going to talk a little bit about writing comments specifically pertaining to the CDT, although I will say that this tip can be applied to other national scenic and historic trails. So if you're thinking about another trail, particularly a congressionally designated trail that is really meaningful to you personally, please do keep this in mind and keep this strategy in mind. So really what we think of as kind of the keystone of considering how a proposed action could impact the CDT are the congressionally designated nature and purpose of the trail. So because the CDT was established under the National Trail System Act, it's managed under the 2009 CDT Comprehensive Plan, which is a Forest Service prepared document that went through its own process, its own NEPA process, that really establishes how the trail should be managed, that applies to management of the entire 3,100 miles of the trail. And that document establishes that the nature and purpose of the trail are to provide for high quality scenic, primitive, hiking and horseback riding opportunities, and to conserve natural, historic, and cultural resources along the CDT corridor. So you see, that's just the long acronym for the CDT there, the Continental Divide National Scenic Trail. And I want to draw your attention to a couple elements of this nature and purposes. The first is that it discusses two primary user groups for the trail, hiking and horseback riding. So when we're considering an action, we do want to consider that those are the intended user groups of the CDT. Now, there are other stretches of the CDT where mechanized or bike use is permitted, and there are some limited stretches where motorized use is permitted under very specific circumstances. But really, when we're considering the CDT and how it should be managed to provide for those two user groups. And the other part I want to draw your attention to are providing for high quality, scenic, and primitive hiking opportunities and horseback riding opportunities. So high quality scenic, obviously the CDT is known for its magnificent view sheds, and then primitive. So in this context, primitive in a land management sense, when referring to a trail, means a trail that is maintained to fairly rudimentary standards. The CDT may at times pass through more developed locations. It may be managed to higher standards, but generally it's meant to be a remote, rugged, kind of isolated feeling trail. And then the final part that I want to draw your attention to is to conserve natural, historic, and cultural resources along the CDNST corridor. So then later in the document, it establishes that the primary area of concern for management of the CDT and for conservation of those natural, historic, and cultural resources is 1/2 mile on either side of the trail. So 1 mile total in width. And that is really our highest area of concern, is projects or proposed actions that would impact that first 1/2 mile. That's also known in land management terms as the foreground viewshed. It's things within a 1/2 mile are very visible to a traveler. It would have a high impact on your experience of the trail. We also do consider actions that might be in the middle ground or the background, so a bit further from the trail. So because of this nature and purpose, those components are really what land management agencies should strive for when they're managing the CDT. Now, what specifically that looks like might differ based on the location of the trail, based on the setting it's passing through. But when I'm looking at a proposed action, I want to think about how it could impact that nature and purpose and tie my comments back to that. That is kind of that evidence that Sharon was mentioning earlier. So I'm going to give a couple of examples to make this a little bit more tangible. If we see, I'm going to bring it back to that logging example that we gave earlier, because I think that's one of the more common ones that we see along the CDT. A proposal for large-scale logging that is visible from the trail, particularly in that 1/2 mile corridor, but also in a larger area as well, is not going to promote a high-quality scenic horseback riding or hiking opportunity. So that is an incompatible management decision with nature and purposes of the CDT, and that's something that you can bring up in a comment. Again, like Sharon said, it's really great in that case to propose a solution. So what we would typically be proposing there would be those viewshed mitigation measures. Another one that I'm going to give an example of is if there's a proposal to introduce a new use on a particular stretch of trail, a new type of recreational use that isn't currently there, that you think could interfere with hiking or horseback riding. That is something that you can consider and comment on. So for example, I know that bicycle use, while it can be totally non-obtrusive in some settings, could also interfere with horseback riders. So that's one way to think about those user groups, is if something could interfere with those two groups' ability to pass through the CDT. And then the third one I want to keep in mind, or give an example of, is another one we're seeing a lot of right now, which is proposed mining or proposed mining exploration. And I think there's many ways that that's incompatible with this nature and purpose, but to tie it to that third portion, because we haven't really looked at that yet, mining located directly on or directly near the CDT is not conserving the natural, historic, or cultural resources along the corridor. And not in all cases, like Sharon said, in some cases, mining is just incompatible. In other cases, what we may be thinking about in a comment is requesting mitigation measures after the fact or reclamation measures. It may also be bringing to the attention of a project preparer the fact that the CDT and associated resources are there. So that's kind of the final thing I want to mention about comments that's really relevant at every stage in the process, but particularly in that first scoping stage, which is that in many cases, the individual preparing a EA, an environmental assessment, or an EIS, an environmental impact statement, simply isn't aware of the presence of the CDT. It is often just completely omitted, not necessarily intentionally, but because it passes through so many jurisdictions, many land managers just aren't familiar with the presence of the trail or may not be familiar with kind of the mandate for the way that the CDT is managed. And so a really effective way that you can write comments for the CDT, if you're seeing a proposed action and you're looking at it and it just doesn't even mention the CDT, it is also helpful and it is valid and it's useful to our work as well to mention that the CDT is in the area. And if you can, to specifically mention where the CDT is relative to the proposed action. And if you're on the ground and you're familiar with that stretch of the CDT, it's helpful to mention what makes that stretch so unique, because that can really vary based on the stretch of the CDT. So in some locations, that scenic viewshed and the beautiful, whether that's a high mountaintop view or an aquatic ecosystem, things like that, a riparian ecosystem, that might be what makes the CDT unique in that location. In other locations, it may be the presence of significant cultural or tribal or historic ties to the trail. So another really important way to comment, particularly during that scoping period when they're considering how to analyze a project, is even to point out the presence of the CDT. So as an example, I want to talk about two comment periods that are going on right now. If you are leaving this webinar and you're feeling really jazzed up, you want to submit some comments this evening, I want to give you a couple of examples. And this first one, you would need to engage with tonight because this comment period is ending tomorrow, but I think it's a really critical one, so I want to bring it to folks' attention. And that is the revocation of the Chaco Canyon withdrawal. So in land management terms, a withdrawal is an area that has been removed from potential oil, gas, or mineral extraction. So it's an area where that extraction will not occur. So the revocation of a withdrawal, double negative here, would be opening the area to that type of extraction. And the Chaco Canyon withdrawal it's a withdrawal that protects a really tribally and culturally and historically significant landscape. So it's the 10 miles directly surrounding the Chaco Culture National Historic Park, which is a designated UNESCO World Heritage Area. This is an area with thousands of documented significant cultural sites. And currently, the Bureau of Land Management is proposing to revoke that withdrawal and open the area to extraction. There's a very short comment period for this. In the spring, the Bureau of Land Management opened a 10-day comment period for the scoping process. And now they have published a draft environmental assessment that was also accompanied by a 10-day comment period. This one, I will say, if you want to comment, is fairly easy to find those kind of template comments for, both on that Public Lands Action Network that I shared earlier, but also if you Google Chaco Canyon comments right now, a lot will come up. And like Sharon said, there is strength in numbers, and there's also strength to, if you want to modify that, if you want to share your experience in that area, if you've recreated in the area, or if you've been to the Chaco Canyon Chaco Culture National Historic Park, that is really worth getting those comments in on. The other one I want to give an example of is a little bit broader and also has a much further deadline. But the Bureau of Land Management is currently proposing a new oil and gas leasing rule. So this comment period closes on August 24th, and it would change how the Bureau of Land Management handles the leasing process for oil and gas extraction. And there's a number of changes proposed, but I think the one that is particularly crucial to the CDT and to communities along the CDT is that it would drastically shorten public participation periods. So currently, throughout the BLM oil and gas leasing process, there's about 90 days of public comment opportunity. So there's a protest period, a comment period, and a scoping period in many cases. The new rule would shorten this to only a 10-day protest period at the end of the process. So this would really, really hinder communities' ability to weigh in on sites and values that they may know exist associated with a parcel that has been nominated for leasing. And it would also really hinder CDTC. We will often raise that in comment periods, we will often point out that a proposed parcel is within the viewshed of the CDT or is very close to the CDT in some cases, and that leasing and then the subsequent development and extraction on that parcel would impede the CDT and its nature and purposes. So commenting in order to kind of develop a record that public participation is important in these situations and that public participation is essential to management of our public lands. So those are two opportunities to comment right now if you want to try putting this into action. But if neither of those catch your interest, I would also just encourage you to go explore some of those tools that I shared earlier in the presentation. Explore the Public Lands Action Network and see if there is a comment period open near you right now that feels significant. Just make yourself familiar with those platforms so that should something come up, you kind of know how to engage in that way. And with that, we are going to transition into question and answer. You can send your questions in the chat, you can raise your hand, and you can also use the Q&A feature, which you will see again on that little black bar at the bottom of your screen, and you may need to use the ellipses feature and select more to find the Q&A. So I'll give folks a second to send in any questions they may have. I will note also that I know we shared a lot of information, so I will give it more time for folks to send in questions. But I also want to note that my email is up on the slide, and that you can please reach out to us at any point in time with any questions you may have. If you spot a proposed action near the CDT, it's always really helpful when folks bring that to our attention. We are not necessarily along every 3,100 miles of the CDT. And when folks point out projects to us, there have been a lot of situations recently where that can spur a lot of action from CDTC. So I would say that also you can just reach out and let me know that something is happening. Anything along those lines is great. We do have a couple questions coming in. The first is, how long are comment periods usually? Sharon, do you want to handle that, or I can as well?
Yeah, I'll take that. So if you're dealing with the most robust version under NEPA, an environmental impact statement, there are legal requirements that were firmly in place. The law is changing, but generally 30 to 45 days is considered a meaningful, reasonable comment period. As we've seen just in the examples that we've talked about here, they can be much shorter, and it's generally left to there's a fair amount of discretion for the agency. This is one example where relationships matter, because if you're working with two reasons. One is if you know the Forest Service employee who's in charge of the project that you care about. One is you can kind of influence that through the back channels too. And because there's so much discretion, you potentially can help shape how long a comment period is. I will acknowledge that a lot of direction is coming from on high right now, and so the ability of individual local staff is more limited now than it has been. But in general, I would say 30 to 45 days is a meaningful and traditional comment period on a major action.
Yeah, and I will add that I think that is part of where commenting early in the process, particularly during scoping, can be really meaningful. I'll share a specific example. Right now, the Rio Grande National Forest in Colorado is redoing their over snow travel management plan, which includes how winter travel would occur on the CDT. And they granted a 45-day comment period to review the draft environmental impact statement that they published, and it's been communicated that the reason it was 45 days as opposed to 30 was because there was so much public interest in the scoping process and because they wanted members of the public to have that opportunity to weigh in. So I think perhaps the hopeful side of me would like to say that I do think participating makes the case for continuing to have those comment periods in some cases. We have another question in the Q&A that says, it sounds like this is the best process we have and that we should trust in the good faith of the administration to take into account our comments. Sharon, do you have any thoughts on kind of just that trust that's necessary here?
Yeah, I mean, yes, I think we do. And I'll just share one thing from the legal perspective. Some of you may be aware that the well-established and guiding regulations that have been issued by the Council on Environmental Quality, which sits in the White House, and have guided the NEPA process really very close since its beginning, have been terminated. I mean, they've been rescinded. And so arguably, they don't have effect in directly binding the agencies in their NEPA process. And it includes some information about the length of comment periods. I do think we just have to engage in good faith and as robustly as possible, because this is democracy in action. And I'll leave you with a nugget of hope. The case law that exists interpreting the statute, NEPA itself, has been in place for a long time. And just because those CEQ regulations have been rescinded doesn't excuse what the courts have said NEPA, the statute, requires. So we need to be using the process and using it as effectively as we can.
I think that is a really great note to end on, Sharon. Thank you all so much for joining us this evening, for kind of your interest in these topics and for learning about this alongside us this evening. So if you have any questions, please don't hesitate to reach out, and we'll also share the recording of this presentation. Please feel free to share that far and wide with anyone that you think may be interested. Thank you all.